Hello, everyone. Thank you so much for attending today's webinar in partnership with Shaw Rosenthal. I just have a few things to go over before we get started on the presentation. If you do have any questions, you can go ahead and enter them in the question box, and the attorneys will get to them at the end of the webinar. If you're looking for more webinars and resources, you can go to hrsimple.com/events, and we do have our own webinars up there as well as partners like Shaw Rosenthal, so you can go ahead and get some valuable information at the site. HR Simple provides easy-to-read HR guides written by top law firms such as Shaw Rosenthal. The Maryland HRM Human Resource Manual is written by Fiona, one of our speakers today. To purchase or learn more about our products, you can go to hrsimple.com/shop. Fiona defends employers in the areas of employment discrimination, wrongful discharge, and wage hour regulation, both in court and before federal and state agencies. She also provides advice to managers and human resources on a wide variety of personal matters and conducts training on harassment, reasonable accommodations, and other issues for both supervisors and employees. She prepares employee handbooks and personnel policies. She assists government contractors in complying with affirmative action obligations. Parker represents management and employment litigation in state and federal courts and in administrative proceedings before federal, state, and local administrative bodies. He also provides advice and counsel to employers regarding personnel matters. He also litigates a broad range of labor and employment disputes, focusing the majority of his time on litigation involving employee mobility, confidentiality agreements, and trade secrets, as well as wage and hour class and collective action. So now that we've learned a little bit about our speakers, I will go ahead and turn it over to them so we can go ahead and get started.
Thank you, Anna, and thanks to the rest of you for joining us this afternoon. I'm Fiona Ong, and my co-presenter, Parker Thaney, and I are partners with Shaw Rosenthal, which is a boutique law firm that represents employers across the U.S. in labor and employment matters. And from the beginning of this pandemic, it's been a total whirlwind as we've helped employers adapt to these, and you hear this word all the time, unprecedented circumstances. We've really seen a sea change in how people work. And I was actually telling Parker the other day that I'd never heard of Zoom a year and a half ago. In fact, Parker was the one who first said to me, let's do a Zoom meeting. And my response back to him was, I have no idea what you're talking about. Well, thanks to Parker for introducing me to Zoom, because that's really become a large part of my life over this past year. So personally, I've come to realize that there are a lot of things that I can do remotely that I never would have been expected to do before the pandemic, and I'm not the only one. So there are a lot of employers and employees who are now recognizing that certain jobs don't actually have to be in the office. And maybe the remote work that was just supposed to be an emergency measure during the pandemic can now be a new normal for certain positions. But what was okay on a temporary or emergency basis may not necessarily be okay on a regular or long-term basis. There are a lot of legal issues that arise when you're talking about remote work as a standard practice, and many of those issues are not intuitive or obvious. So as employers start to think about post-pandemic life and work, Parker and I want to help you recognize how to prepare for and avoid some of those legal issues. Next slide, please. And of course, we want to remind you that we're providing information in this webinar, not legal advice. And if you have questions that are specific to your particular company or situation, you should contact your employment attorney. Next slide, please. So to give you a summary of what we're going to cover today, we're going to provide a brief overview of logistics. Many people had to figure it out when shutdown orders forced people to work from home, but there are some legal and practical considerations that maybe weren't at the top of your radar screen when this whole thing started. So we're going to talk about those. We'll also talk about whether and how the Occupational Safety and Health Act applies to remote workers, and we'll talk about the Fair Labor Standards Act requirements for timekeeping and pay, and we'll also touch on how the Family and Medical Leave Act applies to remote workers. We'll spend some time on reasonable accommodations under the Americans with Disabilities Act, meaning both remote work as an accommodation and accommodations to enable remote work. We'll also talk about a really big issue that may trip employers up, which is what happens when your remote worker is working in another state? That can bring up all kinds of compliance issues. And we'll take that to another level. So what happens when your employee is working remotely from another country? And now I'm going to turn it over to Parker.
Thanks, Fiona. As Fiona said, we'll get started with some logistical items, and I think of this sort of as a discussion of practical considerations and concerns, as well as best practices that employers should be aware of and attempt to implement so that there's clear understanding between the employer and the employee regarding the parameters governing remote work arrangement. So to start, I think it's no secret to any of us on the call that COVID-19 really changed the landscape when it comes to remote work a little more than a year ago. And while we had many employers mandate or offer remote work soon after the pandemic began, not all are returning to work now that a number of employees are vaccinated and folks are more comfortable going out into public. But we are seeing a variety of approaches to a return to work that range from mandating a return to making a return optional, to asking only employees who are vaccinated to return, to simply shifting from an in-person workplace to a remote workplace for a number of employees. And this leads us to some considerations about industry standards. Now, it's important to understand what is typical in your industry, not only as it evolved over the last year, but of course, there are a number of industries in which remote work was prevalent even before the pandemic. And understanding what the industry standard is makes it easier for you to understand what employee expectations might be. Employee expectations as they relate not only to attraction and retention of talent, but also employee familiarity with the parameters that might govern remote work arrangements. So employees who are very unfamiliar with remote work likely need more guidance than those that have been in a remote work situation for years or decades, including time worked that had nothing to do with the COVID-19 pandemic. Some employers are making the decision to implement more robust remote work policies and procedures because of financial benefits that they reap in terms of not having to pay for or administer office space and other overhead. Next slide, please. So one of the first things that Fiona and I would tell you to think about if you told us that you were considering a more robust long-term telecommuting practice would be to develop and implement a telecommuting agreement. And like many other policies and procedures, there's really not a one-size-fits-all approach to a telecommuting agreement, but there are some items that every employer should consider including in a telecommuting agreement so that the parameters are understood. And those can include things such as eligibility for such a program, which might turn on tenure or performance or job category, and ranging to things like the schedule, the home office requirements, equipment and software, expenses, reimbursement, confidential information. And we'll talk about each of those items in a bit more detail in a moment. But here, I think it's important to understand that while this is a best practice, it can have, this sort of agreement can have legal repercussions when it comes to what the employees expected to do while at work, where the employees expected to work, when the employees expected to work, what occurs when the schedule that has been set out is impractical and cannot be followed for a particular day or days. So while it's a best practice, it's certainly something that would have implications on a number of different legal considerations. Next slide, please. As to the work schedule, and again, these items that I'm going to discuss, I would say it's worth including each of these items in an agreement that is between the employer and the employee regarding the remote work arrangement. So we should be thinking about what the agreed upon hours and days for remote work are, and ensure that there's supervisory approval for the agreed upon schedule so that there's no confusion and so that we don't have employees who are attempting to create their own schedule, because although the workday typically starts at 9 a.m. for your particular company, the employee rolls out of bed at 6 and decides, well, all I have to do is walk downstairs and get started, and 3 hours of my day will be finished before my boss can even send me an email or make a phone call to me. So it's important to have those considerations in place. When it comes to the schedule, I'd also recommend that folks consider blocking out particular breaks and lunch periods as well, so that it's clear when the employee is going to be on break or on a meal period and not performing work for the benefit of the employee and employer. We also want to ensure that employees are complying with the schedule that's been set forth, and that can come in a number of different ways. If it's an employee that's logged into your network, you can monitor the login and activity, or it can be as simple as requiring employees to be responsive within a set period of time to telephone calls or emails from the supervisor. Occasionally, when folks are having trouble teleworking and performance is in question, employers will ask that the employee summarize the work performed during the day. Once an employee is remotely working, that employee is not present with the remainder of the workforce. And so it's important that everyone understand what the schedule is, and whether that's a shared calendar or a communication of other sorts, that everyone understands when each other are on duty and performing work. That way you will lose less of the dynamic that you might have had when everyone was in the office together, and there will not be there will be a lower degree of likelihood that folks will be reaching out and not getting responses when they need it. And to that, out of office responses should be up when folks are unavailable, even though they're typically out of the office. I remember feeling quite strange the first time that I said during the pandemic that I was out of the office, because I'd been out of the office for many months. But when I was unavailable, I made sure to put up that notification so that folks knew that if they reached out to me, they'd want to call my office and be able to connect. And I think that's an important best practice for those who are remote working, so that you're sure that folks are actually working when they say they're working, and when they're not working, everyone knows. Next slide, please. So as to work standards and performance standards, these are going to be the same standards that are applied in the office as are applicable to employees who are performing remote work. And it may be an adjustment for some supervisors, but they should be monitoring quantity of work to the extent that's a component of a job, the thoroughness and quality of the work that's been completed, the ability to meet deadlines, and fulfilling other requirements. I mentioned earlier the availability of employees to respond promptly to supervisory inquiries, but they also need to be able to respond promptly to external inquiries or other needs of the business. And so to the extent that that is something that's drafted into your telecommuting agreement, it's easy to hold employees to those standards so that they continue to have an understanding that they're expected to meet those expectations if they want to remain on a remote work arrangement. Next slide, please. So one of the other items that I'd recommend addressing in an agreement and deciding prior to an employee being on a remote work arrangement would be to address home office requirements. And so in this regard, we want to make sure that we have an understanding as employers of the area that our employees are going to be working. I don't know about all of you who are in the audience today, but I've seen my fair share over the last 15 months of folks joining Zoom calls from their beds. And I've sort of wondered if that's what they intended to show everyone on the screen, but we all know that being in an environment where we've got adequate space, lighting, phone service, power, temperature control, internet, and cloud-based tools, all of those are important, but it's also important that we are in an environment that's going to help us be productive. And so it's typical for an employer to require that area not to be in bed, but isolated from other living quarters and main traffic of the household. And that particularly applies to your employees who have roommates or have families and have a lot of activity going on in their home. And so you want them to be in an area that's free from intrusion and non-business noise. And that may be a separate room, or it may be a dining room that's set off and does not have a lot of traffic or noise. But you really don't want someone who's sort of in the center of the activity zones in the home. You're also going to want to have folks with a desk and a chair and other required equipment, such as a phone and a computer. Really not generally a great idea to have folks working remotely without access to those basic office items. And just a note on reasonable accommodations. Fiona's going to get into this in a bit more detail, reasonable accommodations as they relate to remote work. But if you have an employee who had a reasonable accommodation at the workplace, let's say, for example, an ergonomic keyboard, you'd want to make sure that that employee still has access to that reasonable accommodation in the remote work environment. So we're not sending that employee with the ergonomic keyboard to work from home on a laptop that just has an internal keyboard attached to it. We're making sure that we're still granting the same accommodations that we would if the employee were working at the office. As to the reimbursement of expenses, again, an item that can be included in an agreement, and this one, oftentimes there are questions about what's legally required and what sort of expenses must be reimbursed, and do we need to buy our employees telephones and printers and chairs and monitors and things of that nature? And the answer is, as a general proposition, there's not a federal law that requires employers to purchase those items or reimburse employees for their purchase of those items. Now, when it comes to your non-exempt employees, the folks who are not exempt from the Fair Labor Standards Act overtime requirement, those folks must be reimbursed if the costs that they incur would bring them below the minimum wage, because the items that they're purchasing for their home office are really, those are for the benefit of the employer, not the employee. Some state laws do require reimbursement for certain equipment and service fees. So if your employee is incurring expenses associated with their ISP service, that's something to be mindful of and understand the law in your jurisdiction as to whether reimbursement is required under state law. Again, as to reasonable accommodations, the general rule under federal law, you don't have to reimburse, but if you have an employee with a disability who has made a request and the request is being granted, for example, for an ergonomic chair, that is going to be something that's going to be paid for by the employer, not by the employee, because the employer does have that legal obligation to provide reasonable accommodations to disabled employees. Next slide, please. As to file access and security, this is something that employers have struggled with over the course of the last decade or so in the context of bring your own device policies and procedures. And now it's becoming pronounced because employees are not only using their own phones, but when they're working from home, they may be using their own computers. They may be using their work computers, but their work computers are located at their home in connected to their home network rather than being at the office and connected to the office network. They're also likely to be printing things out or receiving hard copy documents that are stored not in their secure office space, but in their home. And so we'd want to reserve the right to monitor employee use of technology and their activities on the company's equipment and software. And in this regard, making sure that your procedures and policies are consistent with any bring your own device policies is important. But when it comes to folks who are working at home, making sure that the physical items are secure as well. So if you have, for example, a clean desk policy at the office, you'd want to ensure that employees understand that there's an expectation that they'll follow the same process at work. Or if they are required to lock their documents in filing cabinets at work, then you'd express the same at home. And it may be that you have some more stringent policies for those employees who are working at home than for employees that work in the office, because the access to the home is different than the access to office space. When it comes to electronic equipment, you may consider, if you do not already implement such a requirement, that employees who are performing their work remotely perform that work only via a VPN, a remote cloud access to the company's systems, to ensure the security of your data and make sure that that data is not leaking into the employees' personal devices and systems and networks. And finally, just as a best practice, making sure that the files that the employee is working on are being saved in a manner that they are accessible to coworkers in the event that the employee is unavailable or leaves the company or is unable to locate documents on their local machine or at their home. Next slide, please. Now, with regard to OSHA and workers' comp, we're moving a bit away from what's included in a potential telecommuting agreement and on to what are some of the legal parameters and ramifications of work at home. So the Department of Labor, during the course of the pandemic, released guidance regarding remote work. And one of the items that it touched on was the perspective of OSHA, which is a government body that's within the Department of Labor. And what the Department of Labor counseled us was that OSHA is not going to be conducting inspections of home offices, nor will OSHA regulations be governing the workplace when it's a home office in the same way that it governs workplaces that are not home offices. But there are some OSHA regulations that will still apply. OSHA will still receive complaints from employees, and employers are still required to track illnesses and injuries that are reported through the OSHA record keeping mechanisms. So we've got to have a general employers do have a general obligation to ensure that there's no exposure to reasonably foreseeable hazards. And in this regard, some of the items that you may consider for a telecommuting policy or agreement might be a requirement that the employee have a smoke detector in the area, or a fire extinguisher, or access to unobstructed exits, or that the office space be clear of hazards that could cause falls. Those are aspects of a telecommuting agreement that would be perfectly permissible and would likely have the effect of improving the safety of the workplace. When it comes to workers' compensation, of course, workers' compensation laws they vary state to state, and it's important for employers to understand that workers' compensation may apply to injuries that occur while working at home. And the important consideration here is that generally, if an injury occurs in the course of employment, it's likely to be covered by workers' comp. That is one of the reasons that I recommend that an agreement regarding telecommuting address set break times and meal periods, as well as a defined workspace, so that if the employee leaves the home office and walks into the kitchen at noon during the scheduled meal time and trips over the family pet, there's an argument that that is not an injury that occurred in the course of employment. As to the Fair Labor Standards Act, there are a number of considerations here that come into play, and some common issues arise due to the close proximity that employees have between their home life and their work life when they're working remotely. As I mentioned previously, sometimes employees will simply roll out of bed and in less than 5 minutes, they're at their desk working. And because of that close proximity, there is a greater potential for confusion as to what constitutes compensable time and what does not, in the case of employees who are non-exempt. And so when we talk about what compensable time is for non-exempt employees, what we mean is that employees must be paid for all time worked, including hours that the employer suffered or permitted to be worked. And so what that means is not just the hours that the employer told the employee to work, but what the employer knew or should have known. So what does that mean? That means that if the employer has a schedule that the employee abides by, then of course those hours are included. If the employer is soliciting work from the employee outside of those scheduled hours and receiving responses, and the employer knew or should have known that the employee would be working. But it does not extend to what the employer could have known. And that's where we draw the line that when an employee is working, but there's no reason for the employer to know that the employee was working, there's not an independent obligation to investigate whether the employee was working in any particular situation. One of the best practices recommended by the Department of Labor is that employers simply have a process available to employees to report uncompensated work. And that offers the employee the opportunity to address the situation and helps the not what could have known standard be clear for the employer as to where further inquiry might be necessary. So having that sort of mechanism allows the employee to report, and then the employer at that point would inquire further. But those are the general parameters as to the concerns. During the pandemic, there was a piece of guidance offered by the Department of Labor. Typically, the workday is defined by beginning during the first, at the time that the employee engages in the first principal activity of work, and then concluding when the employee performs the last principal activity of work. And the Department of Labor provided guidance that seems quite obvious, but if an employee who is working remotely engages in childcare during the workday for a set period of time, that period of time is not compensable. But it's important, and the Department of Labor emphasizes this, that there be clarity about that arrangement. So again, if that's a component of the arrangement, that should be reflected in the agreement. Now, you may alternatively say, childcare during the workday is not going to be appropriate. And in that case, then the agreement should reflect that if there will be children under a certain age at the home at the time that the employee is working remotely, that there should be another responsible adult present to care for the children. Next slide, please. Continuing regarding the FLSA concerns, in order to ensure that we're compliant with the Fair Labor Standards Act, we want to make sure that our non-exempt employees are accurately tracking the time that they worked and that they're paid for all such time. Now, there are a number of different systems that employers use to track employee time. from punch cards to tracking on paper to electronic timekeeping systems, etc. The important aspect of this is that you have something that is accurate and that you are requiring employees to report their time accurately. That does not mean reporting their scheduled time, but reporting the time that they actually work. And so as you see on the slide, that means start and stop times, including meal and rest breaks. And if an employee is working and they are on the clock, but they were not permitted to be working at that time, the appropriate response is not to deduct that time from their pay, but to pay them for that time and then address that separately, either through counseling or disciplinary action. For example, an employee who is authorized only to work 40 hours a week, but works 46 in 1 week, that employee should be paid the overtime for those 6 hours, but then separately be advised that they are not permitted to work overtime without supervisory approval in writing. When it comes to exempt employees, those folks are going to be paid their full salary for the week if they perform any work during the work week. So for folks who are exempt, if they are performing any work, meaning as little as responding to an email during the week, then we would expect to see them paid for the full work week. Now, that doesn't mean that employees can't take leave and respond to an email while they're on leave, but what it does mean is that absent certain statutory exemptions, if you are not paying an exempt employee for a period of time worked, you potentially lose the exemption that applies to that employee because they're no longer considered to be paid on a salary basis. And the consequences of that would be that that employee would then be entitled to overtime for hours worked in excess of 40. An example of statutory exemptions, an absence of a full day for personal reasons other than sickness or illness can be deducted from the employee's pay. But otherwise, those statutory exemptions are really beyond the scope of our discussion today. Next slide, please. With regard to the Family and Medical Leave Act, the important component of this to remember for employers with remote workers is that this eligibility criteria of 50 employees within a 75-mile radius applies to employees based on the office to which they report and from which assignments are made. So if I have 100 employees who are scattered across the country and they all report to my office here in Baltimore, Maryland, each one of those 100 employees is eligible for FMLA because they are all deemed to be working at my Baltimore, Maryland office, and there are in excess of 50 of them. So being mindful of that requirement and not making the mistake of applying their residential address to the eligibility criteria is an important consideration. And with that, I'm going to pass it back to Fiona for a discussion about reasonable accommodations.
Thanks so much, Parker. Okay, thank you. If you are requiring or permitting remote work, you might have to provide reasonable accommodations like specialized equipment to workers with disabilities to enable them to telecommute. You might also, as Parker mentioned earlier, have to provide accommodations that were previously provided in the workplace to those employees with disabilities who are now working from home. And that, of course, is subject to the undue hardship. I'm going to talk about that in a second. You might also have to adjust those in-office accommodations for remote work. So just something to keep in mind. But the other issue that I'm going to talk about now is telecommuting as a reasonable accommodation in and of itself for a worker with disabilities. But first, I want to go over the overall reasonable accommodations process. Because any reasonable accommodation request is going to be subject to the same process, which involves an interactive discussion between the employer and employee. And it's through this process that you're going to get medical information regarding the employee's disability and what are their limitations and what are the possible accommodations that they might need in order to perform their essential job functions or to enjoy the privileges and benefits of employment. Now, I really want to emphasize the second point because most people kind of gloss over that. They just focus on the essential functions piece, but the ADA is actually broader than that. It requires you to provide reasonable accommodations to enjoy the privileges and benefits of employment. So just keep that in mind. Now, of course, the accommodation can't impose an undue hardship on the employer. And remember that if there are multiple accommodations that are effective, you get to choose the accommodation, even if it's not necessarily the most effective or the one that the employee wants. So if there are alternatives to remote work that are going to be effective and the employee wants to work remotely, you can actually say no to the remote work, again, as long as the alternative accommodation is an effective one. So as we are moving back towards returning to the office, many people have gotten used to working from home. Parker mentioned that, and they want to continue to do it, and they like it. But an employer doesn't actually have to allow an employee to telecommute or work remotely unless it's a reasonable accommodation that's required because of the employee's own disability. But I'm sure you're seeing these requests from employees in other situations. So I'm talking about people who are generally just kind of scared about exposure to COVID-19 without having any kind of underlying disability. Maybe they're older. Also, you have employees who have children who are still attending school virtually, or they're worried about childcare issues, or employees who want to minimize possible exposure in the workplace because they have household members, family members who have disabilities, or perhaps are pregnant. Now, an employer might want to try to work with these employees to address their concerns, but the law doesn't actually require employers to do that. Now, if you want to try and help your employees by allowing remote work in those situations, you just need to make sure you're doing it on a consistent basis in order to avoid discrimination claims, which can be based on any protected characteristic, right? So race or sex or age, for example. And let's just look at a particular example. If you allow a white male employee to work remotely because of childcare issues, but you deny a Black female that same opportunity, well, you better be darn sure you have a legitimate and defensible reason for that difference in treatment, okay? So back to the employee with a disability though. So what's happening is that some employees are saying, well, telecommuting is obviously a reasonable accommodation because I've been doing it for the past year and a half. But what's critical to the analysis here is whether they've actually been doing all of their essential functions during that time. In many cases, they weren't. And just because they didn't do them during the pandemic doesn't necessarily mean that the function is not essential. Another part of the analysis is whether telecommuting is medically necessary. And again, just because it's convenient or desirable doesn't mean that the employee actually requires it from a medical standpoint, which is why you're entitled to get that information from the doctor. And then, as I mentioned before, there might be several different possible accommodations, and maybe telecommuting or remote work is one of them, but depending on the disability, there are other possibilities. And going back to that employee who's trying to avoid exposure, perhaps additional protective equipment or locating their workspace away from others or putting up barriers around their workplace might all be reasonable accommodations and effective, that you could choose those accommodations in place of the remote work. But that's going to be a case-by-case assessment. Now, some of you are going to ask me, so I'm going to go ahead and throw it out there. What if the employee could get a vaccine and come back to the office, but they don't want to? Do you have to allow them to telework? Well, the ADA regulations provide that you can't take mitigating measures like the vaccine into account when you're determining whether or not someone's disabled. But, and I'm quoting from the regulations here, the use or non-use of mitigating measures and any consequences thereof, including any ameliorative or non-ameliorative effects, may be relevant in determining whether the individual is qualified or poses a direct threat to safety, end of quote. So in other words, you have to determine if the employee who refuses the vaccine with or without some other accommodation, which in this case is remote work, can perform that essential function of the job, or if they're going to pose a direct threat to their own or other people's health and safety because they don't get the vaccine, okay? Now, I also wanted to warn you that you can't assume that an at-risk employee who gets a vaccination no longer needs a remote work accommodation. There might still be a medical need for that person to work remotely, and that's what the whole interactive process is for. So that's something to explore with their doctor, and just don't jump to the conclusion that just because they're vaccinated, they should be showing back up for work on bright and early on Monday morning. Next slide, please. So there are some issues that came up during the pandemic that are not really going to be applicable any longer. The EEOC had issued some guidance specific to the pandemic regarding the reasonable accommodations process. One of the things is that because of the stress on the healthcare system and limited access to doctors, the EEOC said that the ability of employees to get information from their doctors might be challenged or hampered. And so they suggested that under those circumstances, that normal interactive process, which normally should be prompt and timely, might need to be truncated or delayed. And now with the advent of telemedicine, as well as the fact that many providers are much more available than they were previously, employers can expect their employees to provide the necessary medical information in a timely manner. Another issue was that there might have been pandemic-related difficulties in providing the actual accommodations or maybe doing the accommodations assessment. So, for example, if an employee required specialized equipment to be able to work remotely, but that equipment was not available because of the pandemic, then you as the employer wouldn't have been required to provide that equipment immediately. Most of these equipment shortages have now been resolved or improved. So there is going to be less reason for delay in providing that kind of accommodation. And then finally, the EEOC noted that in normal times, the cost of an accommodation is not really a significant factor in assessing whether or not an accommodation is an undue hardship. So, for example, there was a case against Johns Hopkins Medical Center involving a nurse with a hearing disability, and she wanted the hospital to provide a sign language interpreter at all times at a cost of $100,000, which would double her salary. And the medical center said, that doesn't seem reasonable to us. The court found that the cost of the interpreter was not going to be determinative on that undue hardship assessment, especially given the financial resources and budget of the medical center. But in the course of the pandemic, the EEOC said many businesses are experiencing such severe economic stress that cost actually does become relevant during the pandemic. But again, as we're moving out of the pandemic, cost is going to become less relevant. So that's just something to keep in mind. Next slide, please. So what are some of the other issues for remote workers? Now, remember I said that you need to provide accommodations to allow disabled workers to enjoy equal terms and privileges of employment. Well, if an employee is working remotely as an accommodation, you still need to ensure that they're not denied opportunities that would be available to them if they were working in the office. So this includes attending meetings, including offsite meetings, meaning not even in the office, but perhaps traveling meetings, or participating in training or social events even, and business development opportunities. All of these things you have to be thinking about to make sure that your remote worker is given reasonable opportunity to engage in these activities, and that providing that reasonable opportunity doesn't actually impose an undue hardship on you, okay? Another issue is that the EEOC, they address in their pandemic guidance is whether employers can require at-risk employees to work remotely if the employee actually would prefer to come in. We're going to ignore that whole vaccine issue that I already talked about. The answer here is that you can do that only if you can show that there's a direct threat to the employee or others in the workplace. And that, I mentioned direct threat before, that's a really high bar, okay? So you need to make sure that you can really establish to some degree of certainty scientifically that there is going to be a threat to either that employee or to others in the workplace if they are allowed, if you want to keep them out of the workplace. You can't make any assumptions. You have to go through that interactive process to get the medical information to be able to assess the situation. Next slide, please. I am going to now turn to state issues because in some cases your remote worker ends up working from another state, Maybe they've always lived there and they just commuted across state lines, or maybe they decided to move during the pandemic to their dream home at the beach or in the mountains, or they're following a spouse to another state for the spouse's job, which has come up several times in my practice. So this can bring up all kinds of legal issues. So here, we are really just going to identify issues that you need to be thinking about rather than providing specific answers. And that's because every state has different requirements and laws, just as Parker mentioned before with expense reimbursement. And these laws cover a wide range of topics, and these include things like business registration and income tax withholding and leave and benefits laws and minimum wage and overtime and workers' compensation premiums and so many other issues. Now, during the pandemic, some states issued guidance that certain requirements wouldn't apply to employers whose employees were temporarily working from home in another state. But as these pandemic rules are being lifted, some of those exemptions are also going away, meaning that if your employees continue to work from another state, you'll need to comply with the laws and other rules for that state. Now, before diving into the state laws, I also wanted to raise just a quick immigration issue related specifically to H-1B workers, because there are some significant restrictions on work location that you had to provide in the H-1B petition. And so these employees can only work at the location that's listed in the sponsorship petition. So if your remote H-1B worker is now working at a distance from that location, you may need to file an H-1B amendment petition. In addition, there may be a different prevailing wage requirement for that geographic area. So if this situation applies to you, please make sure to contact your immigration attorneys. Next slide, please. So if you have a remote worker in another state, this could constitute doing business in that state. And there are going to be certain factors that are considered in determining whether or not you're doing business, including the type of business, whether the remote worker is, how long the remote work is going to last, what kind of work they're doing for you, how many remote workers you have in that state. And depending on the state, a single part-time remote worker might be considered doing business. And if you're doing business in that state, that might trigger business registration requirements, which in turn trigger corporate tax reporting and payment obligations. So at this point, I'm going to refer you to your accountant or tax lawyer because those corporate tax, that's just way beyond our scope of practice. So have at it with your corporate people. Next slide, please. Now, there are income tax withholding requirements for your employees. And again, I'm going to refer you to accountants or tax attorney, but I just wanted to mention that those requirements may be triggered by a remote worker in another state. And income tax withholding is usually required where the employee provides the services, meaning that during normal times it was, at your office, but now that they're looking at working remotely, it'll be in their home office. And so some states have what are called reciprocity agreements with certain other states that govern whether or not the withholding applies in the work state or the home state. And the example we have here is a DC employer with an employee who lives in Maryland. And DC and Maryland have a reciprocity agreement that provides that the employee pays Maryland state taxes, regardless of whether or not they're working remotely from Maryland or in the DC office, state income tax, I should say. Next slide, please. So there are so many different types of leave laws, and states are not consistent in what types of leave are required, and even the ones that are commonly required may have different aspects in each different state. So, of course, there are the COVID leave laws that were passed by many states and local jurisdictions during this pandemic, and more generally, there are state and local sick and safe leave or SFL laws that have become increasingly common throughout the United States. But the states differ on what sick and safe leave needs to be provided based on employer size. So some states require paid SSL for everybody, and others say that smaller employers only need to provide unpaid SSL to the workers or may even exempt them altogether. Some laws include or exclude certain workers based on hours worked or the industry that they work in, and there are different rules on accrual and carryover and different reasons why SSL can be used. And recently, thanks to COVID, a number of states have amended their laws to include workplace or school closures based on the public health emergency, but not everybody did that. SSL laws typically cover leave that's taken care for a family member, but the definition of family member varies widely from state to state. So once you get past the child, spouse, and parents, this can include grandparents and grandchildren and siblings and next of kin and those who are considered next of kin even without a legal or blood relationship, and also in-law and foster and adoptive relationships. Also, there are different call-in and notice requirements for employees who need to use leave, both on a scheduled and an unscheduled basis, and different rules on verification and different notice and posting requirements for employers. Does it need to be on the pay stub? What needs to be on the pay stub? All of this is very different from law to law. And of course, there are record-keeping requirements as well. In addition to sick and safe leave laws, there are family and medical leave laws that provide unpaid leave for these family and medical leave reasons similar to the federal FMLA. But these laws might cover smaller employers, provide more leave, or cover different reasons. In addition, there are state paid family/medical leave benefits laws. That's a pretty hot topic right now. And these laws impose a payroll tax or fee on employers and employees, and this money goes into a state administered fund, and then employees can apply to the fund to get payment for certain unpaid family and medical leave reasons. So it's possible, depending on the state, that if you have an employee working there, you're going to have to pay into their fund, and you have to provide certain notices to your employee, and then they may be entitled to certain paid leave benefits that they wouldn't have been entitled to before. Also, many states provide leave for domestic violence or crime victims, and there's laws on parental bonding leave for the birth or adoption of the child. Also leave to attend certain school meetings and activities for the worker's child. Some states provide leave for organ or bone marrow donation. Almost all states provide leave for jury duty, but some of them require paid leave. And there may be other limitations on when employees can be required to show up for work on days that they have jury duty. Many states provide for paid voting leave, and many states provide for military or emergency volunteer work or civil air patrol service. And there's more really random leaves, like when a family member is deployed or to train for the Olympics. I love that one. It seems very timely. Or to serve as an election official or an elected official. So many of these leave laws require the employer to have a certain minimum number of employees in the state, but some of them don't. So it's really important to check to see what leave laws might actually apply to you when you have a remote worker in that state. Next slide, please. Minimum wage. As I'm sure you know, the federal minimum wage has been stuck at $7.25 for ages. Many states, however, have now implemented higher minimum wage rates. So if the remote worker is being paid minimum wage and is now working in a state with a higher minimum wage, you may need to pay that higher rate. Also, a few states, Alaska, California, and Nevada, have laws that require the payment of an overtime premium for working over 8 hours in a day. And Colorado and California also have daily overtime for over 12 hours in a day. I also want to mention that the test for exempt status might be different under state law than under federal law or the law of the state in which you normally do business. So you'll need to double check to make sure your federally exempt employees continue to make the exemptions. Next slide. And there are so many other considerations to think about. You need to, make sure that you're paying into unemployment insurance and workers' compensation coverage if that's required by state law. A number of states have mandated harassment training for employees in the state, which needs to be conducted on an annual or biannual basis. State law requirements might vary on what information needs to appear on the employee's pay stubs, and there might be varying requirements in the timing of paychecks. There may be different requirements on the timing of final pay, some required on the last day of work, some allowed on the next regular payday. There are state-by-state notice and posting requirements, meaning you'll need to provide the notices to the employee, although I don't think you need to require them to put them up in their homes. Certain state laws require specific written handbook policies, so you'd have to add a supplement to your regular handbook, perhaps. And discrimination protections vary from state to state. Hairstyles or natural hair associated with race is a recent trend. It's not everywhere, but it's in an increasing number of states. There's also marital status and personal appearance or any age, not just 40 and over, and many, many other things. I also wanted to mention that licensing or certification requirements for certain positions vary from state to state. So some states may require a license where others don't. And even if both the home and work states require a license, the licensing criteria might be different. And there may be some other very random laws, like Colorado has a job posting law. It's part of their equal pay law that is incredibly onerous with regard to disclosure of wage rates and promotional opportunities. And so I've seen a lot of big companies excluding Colorado from remote work. And Colorado actually just came out and said, well, that's not okay. You cannot just exclude Colorado. I question how they'll enforce it, but that's what they've said. Next slide, please. The international issues are going to be very similar to those for the state-to-state issues, taken up a notch. Again, you have to start with the assessment of whether or not your remote worker is now meaning that you are doing business in that country, which can trigger corporate law and corporate tax requirements. And the criteria for determining this is going to, again, vary widely from country to country. Some of the factors that they will look at are how long is your worker in this country, whether that remote worker has a bricks and mortar office, whether they can bind the company to local contracts, whether they are working on local projects, and what is the scope of your activities as a business in that country, such as other remote workers or projects in that country. And if you're found to be doing business in that foreign country, then of course, again, there are going to be various tax consequences and payroll mandates. And failure to comply with these mandates might even be a crime, meaning not only are there financial penalties, which could be severe, but potentially imprisonment. So one quick solution to this issue, of course, on the payroll side is to use a local in-country payroll provider, because certainly they should be familiar with those payroll requirements. There are a few countries, not many, that provide exceptions for the one-off remote worker. Also, there are about 30 that have bilateral Social Security totalization agreements with the U.S., but this deals only with the issue of Social Security contributions and not with any of the other payroll mandates. And then just like that multitude of state-specific employment laws that we just covered, there are going to be country-specific employment laws on leave and benefits and discrimination and workplace standards and termination and severance and all that stuff. And I also want to mention that a few countries actually have laws specifically governing telecommuting, so you'll need to watch out for that. And that brings us to the end of our presentation, and we have a few moments for questions. So I'm going up. Okay. And Anna has kindly sent us the questions. Let's see. Are many companies looking at the financial benefit of telecommuting, which is making us look at the cost of office space and overhead? That absolutely has been a consideration. I've certainly seen it reported in the media. I've certainly heard it from my clients. Parker, I think you've mentioned that as well. I think a lot of companies are thinking, wow, if we can shrink our office footprint, we could save a lot of money that way. And that is a reasonable decision that many companies are making, and requiring employees to work remotely in many instances. You know, that may work for your company. Ultimately, it may not work for your company. I think that really is a practical decision and not one that is necessarily a legal one. And then, should exempt employees clock in and out for workers' comp issues? That's actually a really interesting question. Parker, I'm going to ask you to jump in there.
Yeah, I agree. When I saw that question come in, I thought that was quite an interesting question as well. Typically, we would say that you shouldn't have your exempt employees clocking in and clocking out, because that's suggestive of non-exempt classification, not an exempt classification. But as I said, the general guidance on workers' comp is to be able to identify when an employee is and is not working by identifying those set break times. And so a step beyond the ability to schedule those times might be to require them to report in some manner when they commence work and when they stop work for a break or a meal or at the end of the day. But it is going to be difficult with certain exempt employees, those, for example, who might respond to an email or take a telephone call at 9 p.m., 4 hours after they've stopped working for the day. And whether you would require those employees to clock in and out during that time, I think is a question that you need to ask yourself, as well as the practicality of exempt workers who really are performing duties at all times. I know, for example, I will take calls from anywhere where I am at the time that the call comes in, whether I am at home or in the car
At a wedding.
or yeah, at a wedding. That's right. So
So, yeah.
that's a consideration that you'll need to make if you require folks to clock in and out. But it's something that you may consider talking to your work comp carrier
Yeah.
or broker about.
I absolutely want to support that because workers' comp coverage is definitely a state-by-state issue, and so it would depend to a large extent on what the state says, in the state where the remote worker is based. And then I just want to hit one final question, which is, in order to be considered working in another state, must they be 100% remote? Not necessarily, unfortunately. So it would, again, depend on the state. So I think you'll really need to look at what would be considered doing business in that particular state. I think if you have somebody who's doing it pretty part-time, the likelihood is less that they would be considered to be doing business that you would be considered to be doing business in that state. But, it's one of those things where there's no magic, 75% or 50% number that I can point you to, because that really is going to depend on the state. And I think that brings us to the end of our time together. And thank you so much for joining us today. Anna, back to you.
Thank you so much, Fiona and Parker.